Yes, Dr. Tusha, session can be started.
Yes, thank you so much, ma'am. Good afternoon, everyone. On behalf of Desh Bhagat University, I welcome all to the workshop on IPR, an introduction to intellectual property rights, organized in collaboration by Faculty of Legal Studies and Patent Cell IIC. It is a privilege to introduce our expert for today, Mr. Khushal Juneja. Mr. Khushal Juneja is General Manager, Innobel IP. He is an experienced IP professional and skilled in patent research and analytics. Rights, client management, engineering, accounting, and taxation. He is experienced in client handling and currently associated with IP cell of more than 50 universities and institutes and 100 plus SMEs and startups. We hope that we gain knowledge about IPR and will learn how to utilize it. With these
Hello, Tusham, you are not audible.
Okay, so is it audible now?
Yes, sir, yes.
Yeah, so I'm just presenting the screen. Thank you for the introduction, Piyusha ma'am. So good afternoon, everyone. Today we have gathered here basically for the session related to intellectual property rights. So as you guys are already from legal background, I hope that many of you might already have studied about the subject, or maybe it will come in your upcoming semesters. So today we are going to study that the basics of IPR, that what it is actually in real life, what kind of things or what kind of creative work can be protected under the intellectual property umbrella, and what are the remedies available in law to enforce those kind of rights in actual, right? So I'll be just presenting my slide. So I hope the slide is visible to everyone. So let us start with the basic introduction, intellectual property rights, what it means as a term, as a definition, right? So as the word says, intellectual property. So I hope many of us might already be knowing about the terminology, that is assets. Assets means all the things that we possess. Now we have two types of assets, as in tangible asset or intangible assets. So tangible assets are those things to which we can touch, which we can feel, and intangible assets are those to which we cannot touch. For example, our ideas, our creative work. So whatever things that have been generated from our mind, from our intellectual acumen, with whatever knowledge we possess, so those are our intellectual property, or we can say intangible asset. Now to protect those assets, government of India provides us some certain rights which are called intellectual property rights. Now these rights are given to our assets only, just like we have mobile phones. These are our tangible assets. We have vehicles, we have smartphones, we have gadgets, we have watches, we have shoes, right? So these are all are our assets, means our property, our tangible property. In a similar way, our ideas are also our intangible property. That means these are our intellectual property rights, which government of India gives us some certain exclusive rights to exercise them. Just like you have a mobile phone, so without your permission no one can use your mobile phone, right? In a similar way, if you have any idea, so by protecting your idea, by protecting your technology, by protecting your creative work under intellectual property right, you will be the exclusive owner of that particular work, or we can say exclusive owner of that particular idea, and without your permission no one can use your idea or technology. Now, coming back to the slide, so what is intellectual property? Intellectual property is basically a creation of human intellect. So, आपकी knowledge से whatever knowledge you possess, whatever things you are creating, developing, or conceptualizing, so all those things get protection under IPR. That means intellectual property rights. Now, these IPR are plays as a role of your tradable commodities. Just like you can exchange any goods, any services, in a similar way, your IP rights, that means your IP assets, can also be exchanged in terms of monetary benefits, in terms of monetary value. IPR also play as a key component for success in every business. Then how we can say that it is a key component for every business? So when you are starting any business, so first what you will do, you will give a name to your business, right? So the name of the company, name of the product you are launching, name of any software application you are launching, name of any kind of service you are giving to your client, right? So that name is very important, through which your customers will recognize you or your brand or your company in the market. So that company, that brand name is the intellectual property, or we can say it's a trademark. So in the further slides, we will discuss about types of IPR also. But as of now, so it also plays as a tool of competitiveness. So IPR is basically provides you exclusive right. That means monopoly rights. So suppose if you have invented something today, now the same company or your competitor cannot use the same technology without your permission, right? Either they have to build something of their own with some certain technical advancement or some modifications into it, right? So in a way, it gives you a competitive platform also for other businesses to grow, for other businesses to innovate. Then nowadays it can be said that it is a new wealth of every nation. So the more innovations happening around the world, the more innovations India is doing, the more we grow, the more in terms of monetary value we grow, the more in terms of economic value we grow. More research that is happening in India, it gives us a more better ranking in terms of wealthy nations. Now, there will be no self-relied innovation without protection of IPR. So, in a basic terminology or in a basic language, so if you can't protect what you are developing, then what is the benefit of innovating, right? So जो भी चीज आपकी है, whatever you are developing, आपने कुछ invent किया है, develop किया है, कोई cartoon character develop किया है, कोई song लिखा है, कोई movie script लिखी है, so if you are not able to protect it, then there is no benefit, right? So IPR gives you that exclusive right of protection, that you will be called as the exclusive owner of that particular property. Now it is also very important for inspiring others, and to basically respect the work of the innovator, to respect the work of the artist, we can say, to respect the work of the creators. So nowadays, digital media we are seeing, right? So there's a boom in the digital industry. So whatever the digital creators are creating, so if we can't protect those work, if we can't protect those artistic work, or if we can't protect those animations or whatever it relates to, so it is basically to respect the work, to respect the knowledge that different kind of persons possess, to respect the talent and to respect the creation, right? Intellectual property right also play as a key role in encouraging technological innovation in the complete society. And also IP awareness is very must in India. If you go, 1 out of 10% might be knowing about what is intellectual property, right? So I can give you live example. In India, we are only filing around 40 to 50,000 patent applications per year, whereas in terms of population, we are competing with China, and China is filing more than 13 lakh patent applications per year. So now you can imagine how much gap is there in terms of basic knowledge, in terms of awareness about the intellectual property rights. Now, before we begin today, we are going to learn about the strategic value of IP. Applying for an IP is must, that whatever you are inventing, or if you have conceptualized something, you should first file it to the Indian Patent Office or the Controller General Patent Office, wherein you can claim that you are the first author or the first creator of that particular work. But with strategic value of IP, it also we'll also learn that how it can be applied to your research work that you are doing in your labs, how it can apply to your invention. So it is not necessary that if you are from a law background, you cannot do a startup. We have multiple examples of famous CEOs who have educational qualification as lawyers, right? So even lawyers can conceptualize, even lawyers can start up their own business, right? In a similar way, it applies to your innovative work also. If you are bringing any innovative policies in your college, innovative policies in the company where you are working, or any kind of innovation in any existing process, to improvise it, to give it more technically advanced, that can also be secured. Or if you are doing any artistic creations, like making any drawing, developing a cartoon character, developing any kind of animation character, or any kind of cinematography work you are doing, so all these things work will all this kind of work will also get protection under umbrella of intellectual property rights only. Now there are 5 main types of intellectual property right that we are going to study today, as mentioned on your screens. I hope everybody is able to see that. So these are the basic 5 types of intellectual property rights that are well known in the market, but there are few others. But today we are going to focus on only these 5 of them. I'll explain you brief what are other types of intellectual property rights also, but just to give you a glimpse over this slide. So the first is patent. So patent, many of us might have already heard about this term. So what is a patent? Patent is just a legal certificate, just like you have RC for your vehicle, right? Which states that this vehicle belongs to you. Just like you have a invoice for your mobile phone, which states that you are the owner of this mobile phone. In a similar way, patent is a legal certificate which will give you exclusive right for your technology. So if you have developed any technology, invented any technology, then patent is the right kind of IP under which umbrella which you should apply to the Indian Patent Office to enjoy the exclusive and monopoly right. So patent gives protection only to the technological innovation in terms of either a product has been developed or a process have been developed. So the main criteria is the technology should be there for protecting any kind of innovation under the patent umbrella. Then second we have is trademark. So trademark is basically a business identifier. We can say that ऐसी वो सब चीजें जिससे आपके कस्टमर्स आपको मार्केट में पहचानते हैं. ट्रेडमार्क इज बेसिकली द trade name through which your customers can identify you in the market. Okay, just like Nike we have, just like BlackBerry we have. So it can be anything. It can be a logo, it can be a symbol, it can be a sound also, it can be a 3D mark, a hollow mark. Even nowadays trademarks is given to the shape of buildings also, just like the Bombay Stock Exchange building in Bombay, Taj Hotel in Bombay. Those buildings have been given as a trademark because they give a certain identity of that particular business, right? Then third we have is copyright. So copyright is mere expression of thoughts, expression of ideas in which you are presenting it. For example, if you are writing any research paper, if you are writing any script, writing any book, any novel, so all those kinds of work will get protection under copyright law. Then fourth we have is industrial design. Industrial design basically provides the protection to the aesthetic value of any product. So if you are involved in any kind of designing, or we can say product designing either of machinery, either of your apparels, either of your clothes, either of your shoes, or if you have developed a unique design for your smartwatch or a mobile phone. So all those kinds of designs will get protection under industrial designs. So in India, they are called industrial design. Outside India, they are called design patents. Fifth we have is semiconductor and layout design of ICs. So this is a bit more technical for you guys to understand. So ICs, I hope many of you might have heard about this term, integrated circuit. So there is some 3D layout on the circuit. So every 3D layout has been defined to perform a particular task. So that particular layout gets protection under this kind of law. It is similar to patents only, but we have a separate law for the protection of ICs. And we have few more types of intellectual property. First is we have is trade secret. So trade secret means all those things which are meant to be kept as a secret between two entities. For example, you have developed some idea and you never wanted to disclose it to someone, but you have only disclosed it to any one person. So you can keep it as a trade secret. Why? Because all the previous 5 types of intellectual property we have studied, they will get published after a certain period of time. That means they will be coming into the public domain at a certain point of time, but there are some things which we want never to become public. For example, I can give you a live example. The actual recipe of Coca-Cola, right? So no one knows what is the actual recipe of Coca-Cola apart from the 2 founders of that company. That's why they never traveled together in a single plane also. Then we have multiple examples of business transaction methods have also been kept as a trade secret by different firms. KPMG, Deloitte have multiple trade secrets. Then your KFC chicken burgers, right? So the actual amount of spices that are used to make those chicken burgers have been kept as a secret, trade secret by KFC company. So we have multiple examples of it. How they can be enforced? They can be enforced by entering into confidentiality agreements or specific agreements related to that particular idea, related to that particular thing, which you want to keep it as a trade secret, and they are fully enforceable by law also. Then another we have is geographical indication. So as the name suggests, geographical indication means the identity given to those kind of products which have become famous from a certain region because they are giving some certain quality standards. So I'll explain this with the help of example. For example, Darjeeling tea, right? So that tea has become famous because of that particular area, that it is being originated from Darjeeling area, and it has some certain quality standards also. For example, Nagpur ke oranges, right? Kolhapur ki chappal, Banarsi silk. So these are all kind of those products which have become GIs because they can only be originated from that particular area if we want to have that particular quality standard. That's why they are well recognized by Indian intellectual property law, that this protection is very necessary for those products which are customary in trade, or we can say that have become the legendary asset, legendary identity of that particular area, that particular class of people, or that particular trade people that have been associated with that particular domain, right? So geographical indication is the identity as a special indication tag given to all those kind of products. Then another we have is domain name. So domain name is also your business identity. We can say that if you want to represent yourself, represent your service, represent your business on the internet or world wide web, so domain names are the first thing that you are going to purchase or that you are going to buy. That means, for example, ipsd20.com or deshbhagatuniversity.ac.in, right? So these domain names help you to market yourself on the online web. So these domain names are also important kind of IP assets for you, and it gets registered at the registrar of domains. Then moving on to the next we have is patent. So I'll explain now here in detail what is a patent actually. Patent relates to any new inventions. New inventions means if you are developing any new technology for the very first time in the complete world, then it can be given a patent certificate, or any new and useful improvement of an existing invention. That means some technology is already existing in the market and you have improvised it by adding some new components into it and increasing the advantages of it, increasing the technical advancement of it. That can also be secured under patent rights. So it is not necessary that every time you have to invent something out of the box. You can simply look out for the problems around yourself, problem in the classrooms where you are sitting right now, problem in your houses as well, problem in your cars as well, because those old technologies have already been invented, right? But still there is a scope of improvement in every technology. That's why we see continuous technological advancements, right? So the kind of smartphone we were using in 2010 or 14 maybe, and the kind of smartphone we are using in 2022, there's a huge difference of technological gap, we can say, right? Why? Because every time some or the other inventor is trying to solve a problem in the existing technology, and with every new solution a patent came into picture. Patent means a new technology came into picture which is protected by a patent right. So you can see the problem around yourself which you want to solve, or you can take help of your technical friends, or if you can take help from your friends or from engineering science background, or maybe some MBA friend. Your MBA friends can also help you in solving some of the other problems, right? So you just need to identify the problems around yourself. Now there are three basic criteria for uh, three basic patentability criteria that are defined by law. The first is novel. So either your complete technology should be new in the world, or there must be some novel components added to it that is making that technology new. Second is that it should be useful. Useful means industry should be able to reproduce it. It can be made in industry. It can be used by others as well. Then only we can say that you have developed a useful patent, or we can say industrially applicable patent or industrially applicable technology. Third we have is inventive. So the inventiveness means it must show some ingenuity and must not be obvious to someone of average skill in the field of the invention. So this is a bit hypothetical situation here. So here we considered a person who is technically skilled in the same domain. Suppose, for example, I have invented a smartphone, right? And I belongs to the domain of EC, let's say electronics and communication engineering, and I have developed a smartphone. And with the smartphone, I have improvised some wireless standards. So wireless technology standards I have invented. Now my developed standards or my developed technology should not be obvious to the person who is skilled in the same art. That means who is also skilled in the wireless standards. Another person उस उस पर्सन के लिए मेरी डेवलप टेक्नोलॉजी ऑब्वियस नहीं होनी चाहिए. और इन सिंपलर टर्म्स हाउ आई कैन डिफाइन इट दैट जो भी चीज आपने बनाई है, या जो फॉर एग्जांपल आई हैव डेवलप्ड समथिंग, सो मेरी उस टेक्नोलॉजी में कुछ ना कुछ टेक्निकल एडवांसमेंट होनी चाहिए जिससे मैं ये बोल सकूं या ये कह सकूं कि मेरी टेक्नोलॉजी, द टेक्नोलॉजी आई हैव डेवलप्ड इज टेक्निकली एडवांस इन टर्म्स ऑफ आइदर एफिशिएंसी, या मेरी टेक्नोलॉजी की एफिशिएंसी बढ़ गई है, और आई हैव डेवलप्ड अ चीप प्रोडक्ट. That means the cost of developing a product that I have been developing is very less than the already existing product in the market. if I'm able to prove those things, that I can say that my technology is non-obvious. That means it is inventive in nature. So these are the three basic criteria which every technology should fulfill to get a patent protection. Now, this is an example of a patent certificate. How it will look like, that name of the applicant, title of your technology, and date of filing, date of grant. So patent. And who needs a patent? Every person who is involved in some or other kind of technological innovation. So sometimes we call it as a jugaad also, right? In India, we use a terminology jugaad. So jugaad is also a technological innovation, or we can say technical invention. When it fulfills all the criteria previously explained, it can also be secured under patent rights. That's why India is very far behind China, because we do the jugaads, we do the technological innovations, and it doesn't get protection in India, but rather they get protection in China. Why? Because we don't have the knowledge, we don't know the value of our assets, because our ideas is should be ours only, right? We should be the exclusive owner of those ideas, those jugaad. So we never intend to protect it due to lack of knowledge. Then this is just for your information that world's first exclusive right, that means world's first patent, was granted in the year 1421 to the inventor Filippo Brunelleschi, and the technology was related to a method of transporting goods up and down the river Arno in Florence. Now, what can you patent? So this is a basic example of a door lock. So door locks we all must have seen in our homes, right? But have we tried to find any problem in the existing door locks? So this person has found a problem that after a certain period of time, so there is a lot of wear and tear on the locks, right? It get worn out, and we have to either change it or partially or completely. So what he did, he invented a simple plate that can be installed on the existing door locks, so that now wear and tear will be less. Plus, it will provide extra security also to the locks, that if we push the gate very hard also, it will not open automatically. So this is the simplest innovation he has done, and he has successfully got a patent also for it. Now, in a single product, what all you can patent? For example, you have a smartphone, right? So a single smartphone is being protected by more than 1,000 patent applications, because there is a not single technology in a smartphone. There are more than 1,000 technologies that are being used in your smartphone, right? So in a similar way, if we talk about a simple door lock, what can you patent? Either complete door lock as a whole can be patented, or if you have invented some unique lubrication to be used in door lock, so then that lubrication can also be secured under patent right, or we can say composition of that lubricant. Third is a machine for making door locks. So instead of inventing the door lock, you have invented a machine to make a door lock, right? So then that machine can also be secured under patent rights. Or a process for making a door lock. That means neither you have invented a product, neither you have invented a machine, rather you have invented a process. That means how to make a door lock. So if that process involves technology, then that process can also be secured under patent rights. Or we can say improvement on any of these. That means 90% of the patents that are being filed in India or abroad are for improvements to existing patented inventions only. I can give you live example, multiple examples I have, but the basic example which you all can relate is of your smartphones itself, right? So WhatsApp we are using. WhatsApp was came into picture I think 2008 or 9. So at that time of WhatsApp and now WhatsApp, there is a huge difference in the technology, right? So many new features have been added. So WhatsApp was already invented in 2008, but every time WhatsApp is coming up with a new update, you will see that what's new in the update. These so many bugs have been removed. These so many improvements have been made, right? So with every new update, WhatsApp is filing a separate patent application to secure that particular feature which is being launched with that particular update. Because as a whole, WhatsApp is already secure, but that feature is invented for the first time. So WhatsApp is securing those features by filing new patent application every time. In a similar way, so smartphones used to have single camera at the back of it, right? Now we have 2 cameras, 3 cameras, 4 cameras. Why? Because some inventor have identified a problem in those smartphones, and they have come up with the solution that with the addition of second camera, a problem of high definition or problem of focus can be resolved, and with the addition of third camera, the problem of wide angle can be resolved, right? So with every new solution to the problem, a camera has been added, or we can say a lens has been added, which is solving a new problem, and a new separate patent application has been filed to secure that particular solution, to secure that particular new technology. Now these are the three, both are patented products. So this is just an example for your basic exercise. So this is a mouse trap. I hope everyone knows that. So both are patented technologies, right? First was patented in 1926, another got patented in 1976. So there were three small improvements that were done in the first product to get another product also patent filed for it. What were these small problems? Initially, there was a metallic strip that has been replaced by plastic that smells like cheese. Now, size of the spring has been increased to solve a problem. Hook has been provided at the end of the arm. So now you can imagine that how small can be a problem, right? So you can see the problem on your chairs which you are sitting right now. You can see the problem in your vehicles while traveling to colleges, schools, in any government building, in the AC of your room, in maybe in the kitchen also you can find multiple problems, right? So during the lockdown period, we all were forced to do so many things which we are not habitual of, right? So that was the time when India and different countries have filed multiple patent applications related to household technologies. Why? Because we were facing many new kind of problems. So all those inventors, innovators have tried to first solve their household problems, have filed multiple technologies either related to cleaning of house, automation of house, or related to cleaning of utensils or cooking of food or cooking utensils, right? So at that point of time, those kind of technologies were on top because they were the necessity when new problems were being faced by the innovators or inventors. Now, as you can see on your screen, these are basic examples of patented products that once they were invented, patent were filed for them. First example is, I think, needle is there, then paper clip, board pin, right? So these were small inventions that once they were invented, patent applications were filed for them. So now you can imagine how small products are patented. Even to this date, also people are still trying to modify these things. How? So the last example which I have heard is of a board pin. Board pin we all use in our office, related to our office work, in our colleges, or maybe in the labs, research labs, right? So or in any lab also we use board pin, or even classrooms also board pins are used. For the notice board also board pins are used. So the last invention which I have heard is, now a person has invented a pin which can tell you the exact amount of force required by your thumb to punch that pin into that particular board, and it will tell you the advanced, give you advanced notification on your smartphones also, that if you want to punch a pin, that this is the amount of force your finger will require. So now you can see that how people are still trying to improvise technologies so that they can make their lives or our lives easier, because at the end of the day, end consumers are we are using the technology, right? So now, he is the youngest patent holder of India. He was actually youngest patent holder of India. He is of only 9 years of age. What he invented was a chess, I think circular chess, so that multiple players can play chess at the same time. So his name is Hideshwar Singh Bhati. So now you can imagine that for inventing something, for innovating something, you don't need to be a technological background. If he can invent, then I believe we all can invent, right? He doesn't know any technology. He doesn't belong to any technical domain, either EC, CS. He was of only 9 years of age when he invented. What he have was a problem solving attitude, that he saw a problem, he tried to solve it, and he was successful in solving it, and now he was the youngest patent holder of India. Now, few examples of patented products by different students from Indian universities only. So this is a multi-purpose waterproof bag device. So I'll give you a brief background of this technology. So during the monsoon rainy season, students find it difficult to carry umbrella and bag together, right? So this student found the same problem and he tried to solve it by inventing a new kind of a detaching mechanism wherein your bag will automatically sense the raindrops and detach out the umbrella. And the main advantage of this mechanism is that if your existing bag was of, let's say, 250 grams, and with the addition of this umbrella and the mechanism, the bag weight has not been increased, increased by more than 50 grams. So this was the main invention, that he has developed that mechanism with less weight into the bag. Another example is Dynamoelectric Device. So this is just a small your play ball, we can say, which you can play and generate and store electricity while playing. Another example we have is automated liquid recycling system. So this example also have a story behind it. So during the lockdown period, when some of the students were stuck in their villages, so they found it very difficult to have clean drinking water, right? So one student has invented this particular technology, that with the help of this technology, it can be installed in any kind of pipeline, either small or big, so that we can have pure and clean and safe drinking water, right? And it is very cheap also, around, let's say, I think 250 rupees per device for small pipes and 500 for large pipes. Then this is another example of a problem solved which we all face still till date. So when we run or when we walk, so our card holders get rotated, right? And the front side gets on the back and back side gets on the front, right? So this is a problem generally we all face. So one student has developed a non-rotating card holding apparatus so that it will automatically regain its position back if it gets rotated. Now, here is another example of one student from another university who has invented a smart dustbin, that wherein you can share your feelings with the dustbin and the dustbin will give you rewards. Plus there are some other artificial intelligence associated with the technology. So he is a BBA student, he doesn't know any technology, but what he have is a problem solving attitude. He always takes friends help from his friends from other departments to innovate and to invent something. Now, this was all about trademark patents. Now, our second topic for the day is trademark. So, what is a trademark? So, trademark is also given in the form of a legal certificate that will give you exclusive protection or exclusive ownership for the brand name or the name that your company represent, or the name of your company, we can say. So for example, a word, a design, a combination of these things that is used to distinguish the goods and services of one person from the others. For example, McDonald's and KFC are into the same kind of business, right? But they both have a different trademark. Why? So that customers can identify different companies can differentiate between them. So if you want to have chicken burgers, we will always prefer KFC. If you want to have veg burgers, then McDonald's is our first preference, right? So the trademarks gives you clear identity of your brand in the market from which your customers can identify. So this is there is a tick mark given on your screen, right? So I don't need to explain you that to which company it belongs. Why? Because these companies are spending so much on their branding that now with their logos itself, you can easily identify the source of the product. That means if any product bears that particular logo, that tick mark, you can easily identify that it belongs to Nike. In a similar way, big yellow M is the logo. In a similar way, we have a unique logo for Desh Bhagat University, right? So that logo is also a trademark and the name has also been trademarked. For example, BlackBerry is also there. Now, trademark can be used to uniquely identify a brand. That means if there are multiple brands in the market, so your unique identity will be represented by your trademark. Now, what trademark protection gives you? It provides you proof of ownership. Ownership means you are the rightful owner of that particular name. It allows you to flag infringement under Trademark Act. That means if somebody else is copying your name or trying to imitate it or trying to sell the products under a similar name, then you can easily file an infringement suit over that person and can remedify and can seek for damages and can claim your rights, whatever that are given in the Trademark Act. Then it also prevent others from adopting a similar trademark. That means if somebody else is if you have already have a registered trademark, that means you already are the exclusive owner, that then now new companies into the market will always try to avoid using that similar name to prevent the legal battles, right? Then it also helps you in licensing your product and services easier, because licensing can only happen if you have the monopoly rights, right, over the name, over the technology. So trademark is one of those things which can help you in licensing your products or services easier. Trademark is basically granted for a period of 10 years and can be renewed for n number of years. That means after every 10 years, you can renew your trademark application, and it is basically for lifetime. And previously, I think I forgot to mention a patent is given for basically of 20 years. That means if you have invented some technology, you will enjoy the exclusive right for a period of 20 years only. After that, it will become public. Now, third types of right we have is copyright. So copyright are basically those rights that are derived from any original literary work, dramatic work, musical work, or artistic work. And these rights can be registered from the moment work is created. That means the moment you are creating something, developing something, they are applicable for protection. You must have seen that C symbol at many places, right? C with a circle over it. So that symbol denotes that all rights have been reserved by the applicant or the owner of that particular work, and no one else can use it without their permission. So basically it provides protection to your literary work. Suppose if you are writing a novel, so or writing a script for any movie, writing a book, writing a research paper, or making any unique presentation also, so all your literary work will get protection under copyright. If you are writing or if you have developed the lyrics of any song, or choreographic work if you have done, cinematographic work you have done, so all these kind of works will also get protection under copyright law only. For example, few novels are given on your screen that are protected by copyright law. So what all things can be protected is mentioned on your screen: movie scenes, actor interpretation, cover, movie editing, pictures, articles cover, lyrics, music cover. Then so these all things can get protection under copyright law. And timeline of a copyright is 60 years plus life of author. Suppose I am the author of a particular work, so the day I will die, plus 60 years, rights will be transferred to my legal successors who will enjoy the rights over my work. So I can give you a live example of Harivansh Rai Bachchan ji, right? He was a great poet. So the day he died, now 60 years are also about to be over. So Amitabh Bachchan ji has filed a case against Copyright Office that this timeline of 60 years should be removed and it should be kept as lifetime. But let's see who will win the case, but still it is in court. But as of now, the timeline of copyright is 60 years plus life of author, and it cannot be renewed. Now moving on to the next we have is industrial design. So industrial design basically provide protection to the outer appearance or aesthetic value of any product. So how it appears from outside, right? How it can be seen from our eyes. So the outer appearance, shape, configuration, surface pattern. So all the branded clothes you are wearing, all the branded watches you are wearing, your mobile phones, smartphones, gadgets, your vehicles. In fact, in vehicles, each and every part gets design registered by either bumper of the vehicle, side profile, mirrors. You won't believe the shoes which you are wearing, right? Even the insole of those shoes are also design registered. So now you can imagine how much important is IP have, or we can say industrial design have. So basically the visual features of shape, configuration, pattern, or the ornament applied to any finished article. So basically anything can be protected under industrial design that can be in the form of a 2D or 3D. The basic condition is it must be original. So designs, those which are known for their visual appeal, can be secured. For example, sunglasses, lampshades. So these are just for examples. A design have a timeline of 10 years in total, plus it can be renewed only one time for 5 years. That means total you will have the protection for your design for 15 years. Now the fifth topic is integrated circuit topography. So as I have explained before, that 3D configuration that is designed on the electronic circuits or the ICs or the product layout or the layout designs, we can say, can be secured under Semiconductor Act. So these technologies are basically used in all the field: your mobile phones, smartphones, automobiles, pacemaker, industrial robot, cameras, spacecraft. So this is also a very important part of IP these days. It is also granted for a period of 10 years and can be renewed for a period of 5 years. So now I'll give you one example of a one product, how a single product can have all types of intellectual property. So this is example of a BlackBerry smartphone. So the technology behind the display assembly of the smartphone will get protection under patent rights. Then the name of the company or the logo of the company, that means BlackBerry will get protection under trademark rights. Third is we have is industrial design. So how a smartphone appears from outside. So its complete assembly from outside will get protection under industrial design registration. Then whenever you buy a new smartphone, you always get a manual with it, that how to use that smartphone in different languages, right? So that manual will get protection under copyright law because it is a literary work. Then another example of a drug, that how a drug can have all kind of IP rights. So the technology, we can say the composition and formulation of the drug that has been invented, or you can see the vaccines for COVID has been invented, right? So those vaccines will get protection under patent rights, and the name through which those vaccines are recognized by us, that means either it's Covaxin, Covishield, or we have different other vaccines also in the market, right? So the names will get protection under trademark rights. So now whenever you will see a TM written on the name, so the TM means trademark has been applied. And whenever you see R written on the name or the logo, you will see that trademark has been registered, right? So this is the basic difference between TM and R. Now, this is a basic benefit of doing IP search, is that what is the benefit? So if you have invented some technology, so it is very necessary to know that you are not reinventing the wheel, or you are not wasting your time in developing something which has already been developed. Because it has happened with many of the inventors, even from IITs or different companies, that they spend years and years in doing some research, developing a particular technology, and when they finally come to apply for a patent, they got to know that similar technology has already been protected or secured by so and so person in different country, right? So to prevent the complete wastage of time and money, it is very important to perform basic IP search. And how you can do basic IP search? Just go to Google, type Google patents. On the first link, click on it. It is exactly similar to Google dashboard only, but here when you will search any technology, you will only get results in the form of patent applications. That's it. By reading those patent applications, you can see what are the current advancements that have been done in a particular field. For example, if you are interested in developing a Bluetooth technology, or we can say the any kind of wireless technology, then you can see that what kind of technological developments have already been done by different companies, either Apple, Samsung, Huawei, right? Or you can also see that what are the problems still existing in those technologies. So by this way, there are some certain benefits associated with doing IP searches. So in a way, you can have an idea that in which area you should work, in which kind of technological domain you should work and involve your efforts, so that you can also develop something or a new unique kind of technology for your own. So this is the basic for today as of now. Now, if you have any questions, you can please ask.
Thank you, Kushal sir.
Thank you, ma'am.
The session is open for the queries, if any. Students and faculty of law, I request them, if there is any query, kindly ask, please.
Being from legal background, if there are no queries, it means either everything is clear to all of you or nothing is clear. So this is the right time to ask for queries. If you have any kind of doubt, or if you have any innovative product of your own, you can discuss, or you can take my number from Piyusha ma'am, then also we can discuss. Or if you have any legal queries, that how this case can be resolved, how these remedies can be provided, so that also you can ask from me. So this is a very important field of law these days, or we can say a booming industry in your law sector. So many of us choose criminal law, civil law while after completing our graduation or post graduation. So IP is one of those fields which is very niche, we can say, and it is going to be very huge market in the upcoming days. And if you wish to choose this as your career, then you should focus on that, how IP is being, because it is totally belongs to corporate law, right? So this is a very vast area. In the 40-minute session, I have just give you a brief explanation that what is actually intellectual property rights. But it is a very vast domain when you actually study about it, and how the corporate licensing deals happen, how the, in fact, market acquisition deals also depend on the IPR assets. So suppose if you have a company of valuation, say let's say 1 crore rupees, right? So your IP assets also plays a very important role in the valuation of your company, or in fact the valuation of any university also, their IP assets plays a very important role. So there's a very huge knowledge that has yet to be gained by you guys. So if you have any queries you want to ask, you can ask me freely.
Recipe is also a patent.
Sorry?
Recipe.
Yes, in India now the patent office has been accepting recipes. So if you have developed some unique recipe, there are basic conditions that needs to be fulfilled. That recipe should not belong to any traditional knowledge. That means it should not be in the public domain. Plus, there are some technical advancements of your recipe. Either you have enhanced the taste of that particular product, or make it cost effective, or in less time you are preparing it, or you have increased the shelf life of that particular product with your recipe. So these things you need to prove with the test, and yes, you can secure your recipe.
I am
Hello.
from law. Suppose I am having some medicine formula. Can I apply for patent? Law,
So
but
what?
apply
But,
for medicine.
yes, yes. If you have any medicine formula, you can apply for a patent. So it is not necessary that if you are from law background, you can apply for patent related to any technology, either of mechanical, life science, biotech. From with any technology, you can apply a patent. So your personal technical expertise doesn't matter into it. The only thing matters is you need to have complete disclosure of the technology you have developed, and if it belongs to any formulation or a composition, then proper testing should have been done to prove the efficacy of that data. That's it.
हेलो
Hello, yes.
Okay.
हाँ जी सर, मैं विशाल बोल रहा हूँ फ्रॉम एलएलबी फर्स्ट सेमेस्टर।
हाँ जी.
तो मेरा क्वेश्चन था कि ये इसमें लॉ का कहाँ पे यूज होगा अगर हम पेटेंट के लिए अगर जाते हैं तो?
So
व्हाट इज द यूज ऑफ लॉ इन दिस फील्ड? इज इट नेसेसरी फॉर लॉ इज नेसेसरी फॉर इट?
yes, law is necessary. So see, patent is yes for technological lawyers only. But if we talk about trademark, if we talk about copyright, if we talk about designs, so on advocates can only prosecute these cases, or if we have a litigation case, so you guys are the right person to handle those cases, right?
So
Only
actually,
for only patents you need to have a technical background. That is the basic necessity. But for other
that's
type,
why I'm asking, because I'm from technical background.
yeah.
So that's why I'm just
then
want
it
to
is
know
the right.
what is the use of law.
Yeah. So this is a complete knowledge. So you must have heard about a patent agent exam, right? So
Exactly.
you need to prosecute any application if you want to involve in any kind of litigation work related to patent. Then you need to be a patent agent. That means you need to clear that technical and legal exam both, right? But for the trademarks, you only need to be an advocate registered on Bar Council of India. That's it. Then you can do the trademark filings, trademark prosecution, trademark litigation work, any kind of work you can do.
Okay.
Please tell us process of filing patent.
Being in any, I'll tell you the general process. So we have 4 patent office in India. First is in Delhi, then Mumbai, Chennai, and Kolkata, right? So there are 2 modes of filing a patent, either online or offline. Through online, you can create your login ID and file a patent application. But we will always recommend to have a patent agent for filing a patent application. Why we say so? Because there are some details that needs to be taken care. That means like patent searching should have been done properly, then patent drafting, which requires exhaustive knowledge of Indian Patent Act. So hire a patent agent and go through them. They will guide you with the complete process of filing a patent application. They will draft your application, then they will prepare all the legal forms that are required, form 1, 2, 3, 5, 6, or maybe 26, and they will file it to the Indian Patent Office on your behalf. If you are in Desh Bhagat University, then you only need to contact the IP cell, which is being taken care by Piyusha ma'am. She will guide you. There is one single form that you need to fulfill. That is an invention disclosure form, in which you have to explain all the details of your technology, of your idea, of the solution you have developed. Just fill that form. Rest all the things will be taken care by your IP cell. We will only disturb you when there is some technical objections or technical queries. Rest, if your invention is fulfilling all the patentability criteria, we will help you to file it. After filing, we will help you in publishing also. After publishing, we will help you in taking it further to the grant stage also.
Okay, sir.
Any more queries, please? I request Dr. Inderpreet Kaur, Head of the Law Department, to please give vote of thanks.
Hello, I'm audible.
Yes, ma'am, you're audible.
Thank you. Thank you. First, I am very grateful to Dr. Piyusha, arranging a very wonderful speaker for us for this workshop, because he beautifully explained the concept of the IPR and the types of the IPR and different angles. Sorry for inconvenience. I'm very grateful to the speaker of the day, who give the eminence knowledge to us on this topic and solve our queries, because from the law background we have many doubts in our mind, because how we can take the benefit of the patent, because only the legal background we can file and we can solve the queries of the others. But like Kushalji explained, that the technological background is required for that, because in law field there is no such thing like a patent, because for patent we have a technological background, we have to invent something. But in law the background, I think it is not right. I think if any I am wrong, then you can clear me, because I have a doubt, because for patenting something we have to do some invention. But in law I think there is no such type of invention, because we have to uh, um, cover up these things and in legal aspects only.
Ma'am, I have given the example also of the youngest patent holder. He is of only 9 years of age. So for patent filing, you don't need to have a technical background, but yes, you only need to have a problem-solving attitude. That if you are facing any problem, just try to solve it on paper, not with the help of technology, only with the help of conceptualization of idea. Then you can take the help of your technical colleagues or technical associates in giving that particular idea a final shape. So that is already happening around the world in different universities, in different companies also. Because if we see in a company, an HR is a normal person, right? But when you see in Google on search, on Google patent search, and if you want to search for any patent applied by any HR, you will see multiple patent applications. Why? Because then HR can only find a problem and a solution to it, but how to technically implement it, she or he will always get help from his or technical associate. So in a similar way, we have to work in a university as well. That if we are from BBA background, law background, or commerce background, or non-technical background, we can say, we just have to identify the problem and just tell our friends and colleagues that how we wish to solve. Then rest we can assure them, or we can rely on them that they will get us a solution in solving that particular problem. So it is a way of interdisciplinary research, or we can say interdepartmental research, which is very necessary for the growth of any university.
Actually, before this, I was always applying my mind to legal patent only. So this is my my query, that because I always tying this with the law only. But now this is clear that we can do anything, we can invent anything. Thank you, Kushalji. Thank you so much. Thank you
Thank you, ma'am.
for such a wonderful session. Thanks a lot.
Thank you, everyone. Bye-bye.
And thanks to my students who are present here. And thank you so much to the other faculty members being.
Thank you, ma'am.